So this is something that we've been talking about, and we actually did a video on a couple of times about Mr. Blackburn. So first, there was a back and forth between Tyrone Blackburn and his client Terrence Dixon, going against Fat Joe and Joe Tacopina, right? So you had that back and forth going on. They filed a lawsuit. There's another lawsuit filed. Joe Tacopina and Fat Joe tried to get ahead of the lawsuit they were filing and file a defamation lawsuit against Tyrone and Terrence. So now we have more happenings, right? You found out that Tyrone Blackburn was going to be served by Joe Tacopina's processor, and Tyrone Blackburn tried to run this dude over, and allegedly he succeeded, because he then got arrested for first-degree assault. I know. It gets better, guys. This has not been the first time, or will be the last time, Tyrone Blackburn has been in hot water, because now we're finding out that a judge is saying that Tyrone Blackburn has to show cause in some of his most recent filings. And if he doesn't, he could be in some very, very serious trouble. Now, we're going to get into it here. Kat Knott Williams covered this document, this memorandum we're going to cover here in a second, and I'll put a link to her live stream where she covered the whole thing in the description. But check out this explanation of what's going on with Tyrone Blackburn.
Repping the hype man, suing Fat Joe. He's got a lot of problems. He's been arrested for mowing down a process server. That's going to be a problem. He's going to have to tell the bar. He could be facing penalties like suspension or disbarment. Now, this is just an arrest, but this is just one of many problems he's got. So Fat Joe, represented by Joe Tacopina, the former lawyer to Trump, coming hot off his big win in the ASAP case, are suing the hype man and the lawyer. And they're saying that you guys have defamed Fat Joe. You guys are basically engaged in a civil extortion scheme for money, that all of this shit is lies, and you're defaming me. Now, the claims from the hype man include that he was forced into 4,000 sexual acts. This begs the question, at what point are you responsible for the sexual act? Like, somebody forces you once, shame on them. Forces you twice, shame on them. At some point between being forced twice and 4,000, don't you have to take some responsibility?
Nope. Not in America today, unfortunately. And Joe Tacopina even came out and said this himself over on TMZ, talking about, we've already talked to several people who were mentioned in this lawsuit, and they said, I don't know what this Tyrone guy or Terrence is talking about. I've never even met Fat Joe. So again, a lot of lies throughout this lawsuit we're seeing. And of course, it looks like it's a move for money. Tyrone Blackburn being behind it. Is anyone surprised? I don't.
The other part of that lawsuit is this brother right here, everybody's favorite $3,000 an hour lawyer to Elon
Alex.
Musk, Jay-Z, Rock Nation. Rock Nation was named in the Fat Joe lawsuit, saying that they're responsible because they were, I don't know, his manager. Alex Spiro, on behalf of Rock Nation, has filed a motion to dismiss swiftly, claiming that there is no legal basis for suing Rock Nation for any of this claims in the Fat Joe lawsuit. This is another problem, but wait, it gets to be so much more that's going on. Check this out.
4,000.
So as you guys may have heard, this lawyer also represents Lil Rod in a civil lawsuit against Diddy. In that lawsuit, several claims against Diddy have been dropped. Several defendants have been dismissed, including Cuba Gooding Jr. and Justin Combs, for not being properly served. When the lawyer tried to get the judge to excuse that and let him properly serve them, the judge said, no, it's too late. They're being dismissed from this case. And then there's the Universal Music Group claims. Universal Music Group was dismissed and went after the lawyer for sanctions. Here are just some of what judges have said about this lawyer's conduct in court.
Now, we're going to get into even more about what judges are saying and the most recent thing that was said about Tyrone Blackburn. But guys, just listen to this explanation of what judges are saying Tyrone Blackburn is doing in court and in court proceedings. It's sounding like Tony Busby, but I think Tyrone has probably been doing this a little bit longer.
So you'll see right here, starting from therefore, while Blackburn may have acted incompetently at times. I mean, that's a rough thing to have somebody say. And then Judge Coate did observe that a reasonable inference from Blackburn's pattern of behavior is that he improperly files cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressure defendants to settle quickly. Yikes. It actually gets worse. Here, the judge has an entire section in his order dedicated as a warning to counsel. I mean, I could read it to you. In light of this, the court finds Blackburn's conduct regarding the motion to dismiss to be unsettling. Blackburn's filings are replete with inaccurate statements of law, conclusory accusations, and inappropriate ad hominem attacks on opposing counsel. Y'all, this man is a warrior. He's
disgusting.
Fighting the entire Diddy legal team, Joe Tacopina. He's fighting Alex Spiro. He's fighting federal judges. He's now been arrested by the NYPD. I mean, an absolute warrior.
Yeah. And I think calling him a warrior is generous, but we're going to get into this most recent filing here because Tyrone, he's got to get his stuff together. I don't know if he can. I mean, I guess if Tony Busby can, so can he. But check this out from the Honorable Judge William S. Stickman. Now, some of you might know, I'm not going to get into it, but there were some proceedings that Tyrone Blackburn was participating in when it comes to the Pastor T.D. Jakes. Some of you may know what's going on in that lawsuit. We're not going to get into it. But what is being said in this memorandum here is in reference to Tyrone Blackburn's work on the T.D. Jakes lawsuit. So check this out. And the judge does not hold back at the beginning of this memo. Defendant, we've got Dwayne Youngblood, we'll just call him Youngblood moving forward, filed a notice of motion to dismiss, a supporting brief, and a reply brief requesting the dismissal of plaintiff T.D. Jakes' complaint with prejudice. That means, y'all know, we know this by now, that if it's dismissed with prejudice, they cannot file this again. Youngblood is represented by attorney Tyrone Blackburn. I think it's time to give him the boo. Man. And he is the signatory of the motion and the briefs. All right. Blackburn is admitted pro hoc vice on behalf of Youngblood. While reviewing Blackburn's brief, the court became aware of the fact that they may contain wholly fabricated quotations from case law, including fabricated quotations from the court's own prior opinion, in addition to including non-existent quotations. The briefs repeatedly misrepresent case law. And guys, again, Joe Tacopina said it in his interview that we covered last week. This is not the first time Tyrone Blackburn has been in trouble and has been reprimanded in this way. And it keeps going. It gets even better. Check this out. Jakes also noticed the issues with Youngblood's brief and addressed them in his brief opposing Youngblood's motion to dismiss. In his reply, Blackburn failed to offer any explanation for the deficiencies and fabrications in his brief. So he pulled again a Tony Busby and was like, yeah, I don't know. Hank Brennan said it best. I made a mistake. I need to save that as a soundbite, by the way. And then it says, in his reply, Blackburn failed to offer any explanation for the deficiencies and fabrications in his brief. Instead, he brazenly attempted to mount I'm not even going to try and pronounce that, a defense asserting that a LexisNexis document analysis of the plaintiff's own opinion opposition briefs reveals a pattern of misquotation, superficial citation, and invocation of authorities that are either inopposite or do not support the propositions for which they are cited. He's not doing his job. Blackburn has a legal and ethical duty under Federal Rule of Civil Procedure 11 and Pennsylvania Rule of Professional Conduct 3.3. We're going to skip through some of this. Specifically, Rule 11 states that an attorney presenting a written motion to the court certifies that to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, the claims, defenses, and other legal contentions are warranted by existing law or by non-frivolous argument for extending, modifying, or reversing existing law or establishing new law. So basically, Tyrone Blackburn messed up. He didn't do the right thing. And it goes on to say the fact that Tyrone Blackburn submitted fabricated quotations and misleading analysis of case law is plain to see from the face of his briefs. When reviewing Blackburn's briefs, the court was perplexed to see quotes attributed to the court's own prior opinions in this case, as well as other case law that was wholly fabricated. So he either needs to fire his paralegal or something, because I don't know what's going on here. The court was also troubled to find that Blackburn's repeatedly misrepresented case law to support his contentions. By way of example, the following italicized portions of Blackburn's brief supported the motion to dismiss, represent a sampling of fabricated quotes. And they have it here. These are all the times that he was fabricated quotes in his brief. Look at this guy. This is a mess. Even after being accused of making false representations in his initial brief, Blackburn's repeated reply, brazenly contained misinterpretations of the law and partially fabricated quotations. And they show them here. Terrible. And then they go on to say, these quotations are merely representative of the fabricated statements in Blackburn's brief. They are additional fabricated quotations that the court does not enumerate in this order. In addition to including non-existent quotations in his brief, Blackburn also cited cases for propositions that they do not represent. So again, using cases that don't even apply. Oh man, he's throwing stuff at the wall and hoping it sticks. And it's a shame, because if his client had an actual case, well, he's just ruining it here, and it's looking like it most likely will be dismissed with prejudice. Attorneys have the duty of candor to the court. They must make reasonable inquiries under the circumstances to ensure their legal contentions are warranted by existing law. Attorneys may not fabricate non-existent quotations from case law or the court's opinion, and may not cite cases for legal propositions for which they do not stand. The court presumes that Youngblood's briefs were constructed by generative artificial intelligence used by Black. Oh no. Tyrone Blackburn is being accused of using ChatGPT. Oh my goodness. Oh, wow. Guys, this is insane. Joe, I know you're watching. I know Joe Tacopina, he watches the show. He's going to have a field day with this. The court presumes that Youngblood's briefs were constructed by generative artificial intelligence used by Blackburn, rather than an effort by Blackburn to personally construct false and misleading briefs, which means Tyrone Blackburn doesn't need to fire his paralegal. Tyrone Blackburn needs to fire ChatGPT. It does not matter. Attorneys have an ethical obligation under Rule 11 and their state's respective professional canons to review every document submitted to a court under their name and signature to ensure accuracy, candor, and overall compliance with ethical obligations. So he actually may be able to get out of this with this statement. He may be able to say, hey, look, Judge, I was swamped. You know, I had my wife, I had my girlfriend. Just throw this in the ChatGPT. And I was in a rush. And then I reviewed it real quick. And I realized at a later time, maybe everything wasn't accurate here. And I needed to correct it. I'm sorry, Your Honor. Goodness gracious. This duty is you cannot delegate it, because I'm not going to try and pronounce this word. So maybe he won't be able to get off from that one. An attorney who signs and files a brief authorized by a non-lawyer, such as a paralegal, there we go, secretary, or intern, is personally responsible for all that it contains. So you can't blame the wife, can't blame the girlfriend. The same applies to artificial intelligence. In other words, Youngblood could not outsource his obligations to the court and his client to a third party yet, including artificial so-called intelligence. Whoever or whatever drafted the brief signed and filed by Blackburn, it is clear that he, at the very best, acted with culpable negligence of his professional obligations. You do not want to hear this as an attorney. The alternative is that he acted in a conscious effort to deceive and mislead the court. At this point, in light of Blackburn's continuing offenses in his reply brief, the court is inclined to believe the latter. So the court is giving him an out here. It seems like the court's saying, hey, listen, Tyrone, we get it. You're lazy, right? Is being lazy a crime? Not really. But when you get caught, you're going to have to be held responsible for it. You were lazy. You told ChatGPT, hey, here's my initial document. Can you take this and write a reply for me and make sure you cite at least, let's say 8 different cases to make it look good and write it in his manner. Here's my previous briefs. So you gave a nice prompt to ChatGPT, but unfortunately, it cited the wrong cases. At this point, in light of Blackburn's continuing offenses in his reply brief, the court is inclined to believe the latter. So the court thinks he used AI instead of, as they said, acting in a conscious effort to deceive and mislead the court. How nice of the court to believe that of Tyrone Blackburn. And now the 26th day of June 2025, it is hereby ordered that the defendant, Dwayne Youngblood's motion to dismiss according to Rule 12 and reply memorandum of law in further support of defendant Youngblood's motion to dismiss are stricken from the record. Dang. Just crumpled all this up and threw it in the trash. In accordance with Federal Rule of Civil Procedure 12A4A, Youngbloods must answer Jake's complaint on or before July 11th. They still get 2 weeks to reply. So this judge is so kind. It is further ordered that Blackburn is ordered to show cause. Here's where it gets ugly, guys. Not to exceed 15 pages by July 18th. So a week after that, their answer is due. As to why his statements in the ECF 43 and 46 have not violated Rule 11B and PARPC 3.3. Good luck with that, Tyrone. And I cannot wait to see what he says there. This show cause is going to be insane. Specifically, Blackburn is directed to thus show cause as to the fabricated quotations and blatant misrepresentations of case law and the court's opinion in his briefs. Possible sanctions include, but are not limited to, monetary sanctions. I mean, who cares? They don't care about that. Including attorney's fees related to the litigation of the motion at issue, revocation of Blackburn's pro hoc vice status, and any other sanctions deemed inappropriate. And this number 4 here, footnote, is going to be important because all that they did was stricken from the record. The court is so alarmed by the deficiencies and potential rule violations in Blackburn's filing that it will not consider any of the substantive arguments raised in Youngblood's motion to dismiss or reply brief. Dang. Judge said it was trash. It is finally ordered that a show cause hearing will be held on July 24th at 2025 at 1:30 p.m. Tyrone's got to show up and explain face to face why he did what he did with the judge. In courtroom 8B, for Blackburn to show cause as to why sanctions should not be issued relative to potential violations of Rule 11B. If Jake's plans to seek attorney's fees in relation to the litigation surrounding the motion to dismiss, Jakes and his counsel must attend the hearing. You know they will be there. Otherwise, all parties and counsel are welcome to attend the show cause hearing, but only Blackburn's attendance is required. Judge say you ain't getting out of this one. Unless, I mean, is he going to have a hearing in the same time for his assault charge? Jeez. Blackburn shall provide a copy of this order to his client, Youngblood, and file a notice of compliance on the court's docket after doing so. Blackburn's attempt to withdraw as counsel in this action does not insulate him from the repercussions of his actions. You can't run, ready or not. Here I come, said the judge. You can't hide. The judge is going to find you and make you pay, Tyrone. God dang. His pending withdrawal of appearance will remain under advisement until the resolution of the show cause hearing. Tyrone cannot run. Tony Busby pulled this. We saw it happen. Tony Busby got in trouble for using someone's login, allegedly, to file some documents. And he got in trouble and he's just like, all right, I'm out of it, Judge. And he was able to get out. Tyrone Blackburn cannot run like Tony Busby was able to run when it came to Jay-Z and Jane Doe. Let me know what y'all think about this. I have not seen anything like this from an attorney, and I haven't seen anything like this from a judge, just reprimanding him in this way and basically holding his feet to the fire, say, hey, you need to tell your client you were using GPT to write these briefs. You need to tell your client about what's going on and that this may be dismissed with prejudice. And you need to show up. And you need to give me a reason. Don't use more than 15 pages of why this was a mistake. And you also need to tell me why you shouldn't be sanctioned. Whew. Tyrone. This is not great advertisement. I want to know what y'all think about this in the comments in the chat.